In this lesson, we're beginning our discussion of federalism. Specifically, we want to focus on exclusive federal and state powers, concurrent powers, and how this all fits in with the Supremacy Clause and doctrine of preemption. Or in other words, right, we really want to explore the relationship between the state governments and federal governments, right? How do we handle potential conflicts between state governments and the federal government, right? How do we know what powers the states have, what powers the federal government has? How does it all interplay, right? Remember, in our very first video, we said this was a big deal when the framers drafted the Constitution, right? They create a centralized government, the federal government, but they don't eliminate the state government. So this leaves us with two layers of government, which leads to a big question. How do we handle the relationship now between these two layers, between the federal government and state governments? Well, this is the idea of federalism, and this is what we're going to talk about in today's lesson. So from a constitutional law fact pattern perspective, though, if we're thinking about issue spotting, really any time we see any potential conflict between a state action and federal action, we have to consider federalism issues. And this is commonly presented in fact patterns where you see the state government passing law, right? You're going to have a state government that's passing some kind of law. The question is going to be, number one, does the state have the power to pass this law? If so, is there any possibility that this law is in conflict with the federal government, right? Because if so, we're going to see under the Supremacy Clause, most of the time that law is actually going to be preempted and void, right? Because we know federal law is the supreme law of the land. But we're going to talk about it, right? There's a whole analysis here that we have to think about. But step number one, right? Anytime we see a state government passing a law or the state taking any action, we have to ask, well, does the state have the power to take this action, right? It's very similar to our discussions of Article 1, 2, and 3, right? Where we said, look, if Congress is taking an action, we have to ask the question, does Congress have the power to take this action? If the president's taking an action, we have to ask, does the president have the power to take this action, right? If the federal court is taking some kind of action, we have to ask, right? Does the federal court have the power to take this action? Well, same idea with the states, right? If we see a state taking an action, question number one has to be, well, do the states have the power to take this action? Now, granted, this analysis will be a little bit easier than our discussions of Article 1, 2, and 3, or more straightforward, but nonetheless, right, we want to run through it. So the idea here, though, is when we're thinking about exclusive federal and state powers, we can just get into it. The best way to kind of visualize this, I think, is with a Venn diagram. So I'll draw this up on the board for us, right? A simple Venn diagram. And let's say on the right side, because I happen to draw this one a little bit bigger, right, we can make this exclusive federal powers, and on the left side, we can make this exclusive state powers, right? And of course, we know that we're going to have some concurrent powers in the middle, right, where both the states and federal government have the power to take actions that fall in the middle of the Venn diagram, right? But this is the idea, right? We're going to have some things that are exclusive federal powers and some things that are exclusive state powers, but we're going to find that probably most powers fall in the middle, right? Where both the federal government and state government are going to have concurrent power. And when the federal government and the state government have concurrent power, that's where we're going to see, we really see the most federalism issues with the Supremacy Clause, Preemption, and the Dormant Commerce Clause, which we're going to get into in our next lesson. But let's talk about exclusive federal powers, right? This area of the Venn diagram, and exclusive state powers, kind of this side of the Venn diagram, starting with exclusive federal powers, right? So the idea here is there's really two ways we know a power is exclusively a federal power. Number one, right, if the power of the states is expressly limited in the U.S. Constitution, right? So for example, we have things like the treaty power and the coinage power, right? If we look in the U.S. Constitution, we know that the president has the power to negotiate treaties and Congress has the power to ratify treaties. But if we actually look at the language of the U.S. Constitution, it expressly limits the power of the states to enter into treaties with foreign nations, right? The Constitution itself, actually, the words expressly written in the Constitution say, hey, the states are not allowed to enter into treaties with foreign nations, right? It's expressly written in there, so we know the treaty power is exclusively a federal power, right? It would go in this area of the Venn diagram. Same thing with the coinage power. Right, the power to coin money is exclusively vested in the federal government. The power of the states to coin money is expressly limited in the U.S. Constitution, right? This is why California doesn't have California currency and Texas doesn't have Texas currency, right? The states are expressly prohibited from coining their own money under the U.S. Constitution, right? So we know the coinage power is exclusively a federal power. Right now, in addition to some powers that are exclusively federal, because the power of the states are expressly limited in those areas, we do have some inherent federal powers where the Constitution doesn't necessarily prohibit the states from regulating in these areas, but due to the nature of the power itself, we're still going to say it's exclusively a federal power, right? This would be, first and foremost, something like the power to declare war, right? We know Article 1 vests the power to declare war in Congress. Now, nowhere in Article 1 or anywhere else in the Constitution does it say, though, that the states are prohibited from declaring war with foreign nations, right? The power of the states to declare war is not expressly limited, but we know from the nature of the power itself, right? The power to declare war is so dominant and intrinsic to our federal system, that's not something that the states are going to be allowed to do. We would say that's inherently an exclusive federal power, right? The power to declare war. So we really have two types of exclusive federal powers, right? Number one, if the power of the states is expressly limited. Number two, if it's inherent, right? If the nature of the power itself is so dominantly a federalist idea, like the power to declare war, right? Anything that's really involving relations with foreign affairs, we're going to see are most often dominated by the federal system, but definitely something like the power to declare war, we know is inherently an exclusive federal power, right? So these types of powers we would say exclusively federal. Okay. Well, what about exclusive state powers? Well, if you read through the Constitution, right, we know Article 1 vests a lot of power in Congress, Article 2 vests powers in the president, Article 3 vests powers in the federal court system, right? So the Constitution is just divvying out all these powers to the federal government. So you get through all of the articles of the Constitution, right, and it says, Congress, you get these powers, President, you get these powers, federal court system and Supreme Court, you get these powers. Then you get to the 10th Amendment, and it says, the powers not delegated to the federal government by the Constitution are reserved to the states or to the people, which basically means, hey, look, if it's not here in the Constitution, if we didn't vest this power to any particular part of the government and the U.S. Constitution, those leftover powers are reserved for the states or to the people, right? This is the 10th Amendment. And this is what we would think of as exclusive state powers. Now, important to recognize, in theory, this sounds like, oh wow, anything that's not in the Constitution, that's reserved for the states or for the people. That's a very expansive, broad amount of exclusive state powers, right? And in theory, the answer is yes, but in practice, we know that this is very limited, right? Because of how broad things like the taxing power are, and the spending power, and the commerce power, and things like Wickard v. Filburn, which we talked about with the aggregation doctrine. We know that this power, this exclusive state power under the 10th Amendment, in practice really shrinks and shrinks and shrinks, right? And there's very few exclusive state powers, truly exclusive state powers under the 10th Amendment. But there are some things like establishing local government, right? For the states to set up their local governments, right? That's an exclusive state power. Regulating purely intra-state activity, right? Activities that have no effect on interstate commerce, we would say is a pure state, a purely exclusive state power. But remember, under cases like Wickard v. Filburn, right, we know a farmer who's growing wheat for his own personal consumption can be regulated under the Interstate Commerce Clause, right? So again, it's very limited, but if you do truly have a purely intra-state activity, that is an exclusive power of the states, right, to regulate. So again, things like establishing local government, pure intra-state activities can be regulated by the states and only by the states. We know the federal government doesn't have the power to regulate pure intra-state activity, right? This is cases like United States v. Lopez, possession of handguns in school zones, right? The federal government cannot regulate pure intra-state activities. So there are some exclusive state powers, but again, the majority, then it's going to fall in the middle, right here, where we have this blacked in, right? These would be concurrent, right? Just gonna write that up. These right here in the middle are concurrent powers, right? Powers that are not exclusively federal or exclusively state. They fall in the middle, where the state governments can regulate in these areas and the federal government can regulate in these areas. This is where most powers are going to fall, right? The power to tax, the power to spend, right? We know that the federal government, right, Congress has the power to tax, but nowhere does it say in the Article 1 under the taxing power that the states don't have the power to tax, and it's not inherently a federal power. So this is how both the federal government can tax and the state governments can tax, right? And you've probably paid, right, if you earn income, right? In most states, there's a few states that don't have state income taxes, but in most states, right, you'll pay a federal income tax, right, to the IRS, then you'll pay a state income tax, right? Because both the states and the federal government have the power to tax, right? Same thing, power to spend money, right? Well, state governments can spend money, the federal governments can spend money, right? Most powers we'll find are concurrent, right? The power to make law itself, right? We know the states can pass law. States have the power to pass law. Federal government, Congress has the power to pass law, right? So the states have judiciary power. The states have enforcement power. States have legislative power, just like the federal government does. So most powers we're going to find are here in the middle, right? Essentially, unless the power of the states is expressly limited or it's an inherent federal power, right? Things like the power to declare war, most powers are going to fall in the middle, and we're going to say they're concurrently state and federal powers, right? And then remember, there are a couple exclusive state powers: power to set up local government, power to regulate pure intra-state activity. But we'll see over time, these exclusive state powers just continue to get diminished and diminished and diminished as we interpret things like the taxing and spending power to be broader and broader and broader, right? These areas that are truly exclusively state powers continues to shrink, right? But this is the idea, right? This Venn diagram sums up what state powers are, what federal powers are, and what concurrent powers are. So the first thing you would want to do if you're looking at a constitutional law fact pattern, right, and you see a state government taking an action, right, you want to try to put it in the appropriate box on this Venn diagram, right? Is this exclusively a federal power, exclusively a state power, or is it concurrent, right? So if you see a state passing a law, right, well, you know that's a concurrent power, right? States have the power to pass laws. Federal government has the power to pass laws. Now, if the state government's trying to do something like declare war with a foreign nation, enter into a treaty with a foreign nation, trying to coin their own currency, you know those are exclusive federal powers. The state doesn't have the power to take those actions, so it's unconstitutional, right? You don't even have to go through the rest of the analysis. The state doesn't have the power to take exclusively federal power actions, right? Now, if you see that the state government is taking an exclusively state action, right, you put it in this box. Well, most of the time that's going to mean it's a constitutional action, right? If they're setting up a local government, if it's a pure intrastate activity, right, which we talked about under the Commerce Clause, though, would be its own analysis. But if you did have an exclusive state action, right, or exclusive state power, right, states taking an action that's an exclusive state power, right, generally that's going to be constitutional. But like we said, most of the time you're going to find that the power is somewhere in the middle, right? It's a concurrent power. The state has the power to do this, federal government has the power to do this. The next question then will be preemption and the Supremacy Clause, right? Is there any conflict potentially between the state law and the federal law? Right, and that's what we're going to talk about in a minute here. Now, before we jump into that, there is one other thing I wanted to touch on, right, in this lesson. And we did touch on this, right, when we were talking about South Dakota v. Dole and the Commerce Clause and the taxing and spending power. But I did want to bring it up again, right, because federalism, you'll see, kind of, it shows up in different parts of constitutional law. It's hard to talk about any one area without also bringing into it federalism issues. So we did discuss this a little bit, but I also want to frame it under federalism so we have it organized in our heads, right, as we go to issue spot fact patterns. And this just deals with federal regulation and taxing of states, right? Important to recognize here that the federal government has virtually unlimited power to regulate and tax the states, right? So remember, South Dakota v. Dole, federal government wants each state to maintain a legal drinking age of 21, right? How do they get the states to do this? Well, they encourage them by conditioning state highway funding, right? 5% of their federal funding on maintaining a legal drinking age of 21. And remember, we said that was constitutional, right? That federal government has virtually unlimited power to regulate and tax the states. This would include things like encouraging state action by conditioning, right? Encouraging state action by conditioning federal funding. Kind of a tongue twister there. Sorry about that, guys. But federal government does have virtually unlimited power to regulate and tax the states, right? The main thing that we're thinking about here is remember that Congress can do this so long as it's exercising an enumerated power, right? It has to be relying on the taxing power, the spending power, the commerce power, the 13th, 14th, and 15th Amendment enforcement power. Maybe it's the necessary and proper clause in conjunction with another enumerated power. And we talked about all of those enumerated powers. But remember, yes, Congress does have to rely on an enumerated power when it's regulating the states. So long as it's doing that, though, it virtually has unlimited power to regulate. And what I was getting at is there's a difference, right? We need to make a distinction between regulating state activity and compelling state activity, right? Congress cannot compel the states to enact specific legislation, right? Congress cannot tell the states, hey, all of the states, you have to have a minimum drinking age of 21. We're forcing it, we're compelling you to do it, right? They probably don't have the power to do that, but they can use the taxing and spending powers to encourage the states to maintain a legal drinking age of 21, right? By conditioning federal funding to the states, right? There's a difference between encouragement and compulsion, right? And that line's not always clear, right? Imagine that Congress said, hey, we're going to condition 99% of your federal highway funding on maintaining a legal drinking age of 21. Right, well, that would probably rise to the level of compulsion, right? If you're conditioning 5% of federal funding, right, that's an encouragement, that's an incentive for the states to enact specific legislation. But if it rises to the level of compulsion, right, generally Congress is not allowed to do that, right? Congress cannot compel the states to enact specific regulation, right? But important to recognize that the federal government generally does have virtually unlimited power to regulate and tax the states, and vice versa to that, we would say the states have virtually no power to regulate the federal government, right? States can't regulate the federal government or tax the federal government except in very limited indirect ways, right? The state of California can tax a federal employee, right? So you have an employee that works for the federal government, right? Their salary is given to them by the federal government. Well, if that person resides in the state of California, the state of California can tax that income, right? A very limited kind of exception, but for the most part, right, the states cannot tax the federal government or try to regulate the federal government. That's not going to work. But on the flip side, the federal government does have virtually unlimited power to regulate and tax the states. The one thing you have to look out for is compulsion, right? If Congress is actually attempting to compel the states to enact specific legislation, that's usually not going to work, right? You can't compel states to take activity, to engage in activity they're not already engaged in. But if the states engage in the activity, generally you can regulate that activity in a lot of ways. The other thing, though, that we have to look out for is compulsion, right? You can't compel the states to enact specific legislation, but you can use things like the taxing and spending powers to encourage the states to take or enact specific legislation. Just one other point I wanted to make here when we're thinking about federalism, and we did talk about this a lot when we were discussing South Dakota v. Dole and the taxing and spending powers, commerce power. If you want to go back and rewatch that, there's some federalism issues interwoven in those cases, right? But the easy thing to remember here is, for the most part, federal government has virtually unlimited power to regulate the states. The one thing we want to look out for is whether that regulation is rising to the level of compulsion, right? They can regulate, they can't compel, right? That's the main idea there. But otherwise, right, when we're thinking about, back to this Venn diagram, right? States are passing law that they have the power to pass, right? Just because a state has the power to pass law doesn't mean they can pass any law that they want, right? If the states pass a law that conflicts with federal law, we're going to have some problems. So remember, step one, anytime we see the state passing a law or taking action, we have to put it in the appropriate place in the Venn diagram. If it is a concurrent power, which most of the time it will be, right? And the state government and federal government both concurrently have the power to take this action. The next question is going to be whether there's any potential conflict between the state action and the federal action, right? Or between the state law and the federal law. And the starting point rule here is that under the Supremacy Clause, federal law is the supreme law of the land, right? This is Article 6, Section 2, Supremacy Clause. Again, federal law is the supreme law of the land. So starting point rule here is really easy, right? If we see a direct conflict or even an indirect conflict between federal and state law, the federal law controls, right? Federal law is the supreme law of the land. So if there's a conflict, we say that the federal law preempts the state law. The state law is void and the federal law controls, right? Very straightforward. There's two types of preemption, right? When we're thinking about the Supremacy Clause. We have express preemption and implied preemption, right? Express preemption, we basically already talked about, right? This is where we have powers of the states expressly limited in the Constitution, right? The treaty power, the U.S. Constitution says, hey, look, states, you do not have the power to enter into treaties with foreign nations, right? Well, if a state tries to pass a law saying that they do, right, they can enter into treaties with foreign nations, that would be expressly preempted, right? Federal law, the U.S. Constitution, expressly preempts state law when the federal law expressly prohibits state regulation in the same area, right? We see this with the treaty power and coinage power, but also, right, and where you would see this most often is when Congress is passing acts, right? Congress is passing law. They can include an express preemption clause in the law, right? They can pass a law and say at the end, right, they can add a clause or a provision to the law that says, oh, and by the way, states are not allowed to regulate in this same area, right? So they could pass a law about, federal aviation laws, right? They could say, hey, look, public airports have to have runways that are 200 feet wide. That's the federal law. States are not allowed to change this or regulate in the same area, right? This is our exclusive regulation. The states are not allowed to regulate the width of public airport runways, right? So that would be express preemption, right? Congress is actually adding an express preemption clause in the law, right? And so if the states tried to come in and regulate that area, state comes in and says, well, runways in the state of Texas can be, 250 feet wide or 150 feet wide, right? They add a different rule to it. It's going to be expressly preempted, right? You can't do that if you're a state, right? If the federal law expressly prohibits state regulation in the same area and a state attempts to regulate in that area, we say the federal law expressly preempts the state law. So that's usually really easy to see. That would be called basically just a preemption clause in the actual law itself, right? That's express preemption. Notably, you could also, if your Congress, add what is referred to as a savings clause. This would be Congress saying, here's our federal law, but hey, by the way, states are permitted to regulate in this same area, right? If Congress says that in the law, that's called a savings clause, then the states can regulate in that area, right? The theme here is it's all about congressional intent, right? What did Congress want to happen here? Did Congress want or intend for the states to regulate in the same area, or does Congress not want the states regulating in the same area? So if Congress expressly states their intent, right, then we know. And if Congress says when they pass the law, hey, the states cannot regulate in the same area, if the state tries, that's express preemption, right? Now, more commonly, what we're going to see on constitutional law fact patterns is issues that deal with implied preemption, right? And there's really three types of implied preemption, right? We have what's called field preemption, and we have direct conflicts and indirect conflicts. So we can start with field preemption, right? So federal law implicitly preempts state law when Congress intended for the federal law to occupy the entire field. Right, so the language is important to kind of keep in your head and memorize here. This comes from Rice v. Santa Fe Elevator Corporation. Right, intent to occupy a field can be inferred from a framework of regulation so pervasive that Congress left no room for the states to supplement it, or where there is a federal interest so dominant that the federal system will be assumed to preclude enforcement of state laws on the same subject. Right, or in other words, the idea here is the more detailed a regulatory scheme is that's passed by Congress or that is federal law, right, the more detailed, the more pervasive it is, the less room it leaves for the states to supplement it, right? That shows intent that Congress really didn't want the states to be able to regulate that area, right? So something like federal aviation law, to stick with our airport example, right? Federal aviation law. We have the federal rules of aviation or federal regulations of aviation. I'm not sure exactly what that body of law is titled, but there is a federal body of law devoted to aviation, right? Every possible little rule I'm sure you could imagine with the way that airplanes are going to be constructed and flown and what the airports have to look like. This is all governed by a federal aviation body of law, right? And it's very detailed, it's very pervasive. I'm sure down to the, width of the tires, to the type of training a pilot has to have. There's no room in federal aviation law for the states to come in and try to supplement it or add things or take away things. It's a very detailed framework, a very extensive body of law, right? So that we're going to say is field preemption, right? So the way I draw this is kind of like this, right? There's going to be all of these things like federal aviation law, these fields that are detailed and that are regulated in great detail by the federal government, right? Things like federal aviation law and, you name it. All of these bodies of law, right? And let's say that these are all federal bodies of law, right? Federal aviation law, federal, right, bankruptcy law, federal, right, any federal body of law that you want, right? You just go down the list and they're all detailed in a lot of detail, right? The framework, the regulatory schemes are pervasive, right? There's no room for the states to supplement these areas. So the deal is when states go to pass law, right, or regulations, they have to very carefully dodge all of these areas, right? Because if they come in and they regulate in an area that is already regulated by the feds, it's going to be preempted, right? If they touch on a field that is regulated pervasively by Congress, that area of their law is going to be preempted, right? So imagine we have a field right here, right? And a state passes a law that cuts right across it, right? So this area, we have the state coming in and touching on an area, a field that is already regulated by Congress or the federal government, right? How does this play out? And important to recognize, it doesn't matter if the law doesn't necessarily conflict or even supplements the field, right? So imagine here we have, right, I'll use a hybrid of a real case here. Let's say that we have the federal government passes a law that says if you're an alien, right, if you're immigrating or you're an alien of the United States, you have to carry a form of identification, right? That's a rule that is passed by Congress, right? Say that's federal law. That's not federal law, I'm just making this up, but let's say that that is passed, right? You have to carry some form of identification on your person if you're an alien, right? So let's say that a state then passes a law in that same field and says, hey, look, if you are an alien and you're not in possession, right, you violate this federal law, you have to pay us, our state, a fine of $100, right? So they're imposing a penalty for breaking this federal law, right? If you don't have your identification on you, you have to pay the state of California $100, right? Well, that state law, that California state law would be preempted by federal law because that field, right, this field of immigration and carrying a form of identification, right, that area is already governed, right, is already fully regulated by Congress, right? There's no room for the states to supplement it. So even if they come in and they add something that supplements it or, imposes a penalty for violating the federal law, even if it's not in direct or indirect conflict, they're not allowed to even slightly touch on these fields, right? Because Congress has left no room for the states to come in, right? So no matter how small it is, that law will be preempted by federal law, right? So field preemption is one of the most strongest of these categories of implicit preemption, right? If Congress has come in or the feds have come in with a very pervasive framework of regulation that leaves really no room for the states to come in, right? If the states try to touch on that field, no matter how slight, that area that touches in the field is going to be preempted. The states can't do that. In this second half here, where we're talking about or where there's a federal interest so dominant that the federal system will be assumed to preclude enforcement of state laws on the same subject. This is kind of like inherent federal powers, right? If we were dealing with a field that is something that's very inherently federal. Think about like foreign affairs, things like immigration, right? That's kind of why I used an immigration example, right? Those are going to be more even so inherently federal, right? So that could be a part of your analysis as well, right? If it's something that's very much dealing with foreign affairs, right, that's going to be something that's an interest that we're going to say is very dominant to the federal system. And there could be this assumption that we're going to preclude enforcement of state laws on the same subject just by the nature of the law itself, right? Things like immigration, foreign affairs, this would be treaty power, coinage power, right? Things that are very much dominant to the federal system. There's even less power for the states to get into those areas, right? So another factor to keep in your head here. But the deal with field preemption, remember, no matter how slight that is, even if it doesn't necessarily, right, the state law doesn't necessarily conflict with the federal law, even if it's just touching on a field that's regulated pervasively by Congress or the feds, it's going to be preempted, right? You can't do that if you're a state, right? So that's field preemption. The next we have under implied preemption is federal law implicitly preempts state law when the state law directly conflicts with federal law. So this is very easy to see. Basically, if it's virtually impossible to comply with both laws, right, we're going to say it's a direct conflict and the federal law preempts the state law. So imagine, right, we can go back to our other example that federal law, under federal regulatory aviation law, the feds have established that at public airports, runways have to be exactly 250 feet wide, right? It can't be 251 feet, can't have a runway that's 249 feet. The runways must be exactly 250 feet wide. We'll say Texas attempts to pass a law that says airports in the state of Texas are going to have runways that are 200 feet wide, exactly 200 feet. Runways can't be 201 feet, they can't be 199 feet. Well, if you're building an airport in Texas, it's impossible to comply with both laws at the same time, right? How wide do you make your runway? Do you make your runway 250 feet? If you make your runway 250 feet, you break the Texas law. If you make your runway 200 feet, you break the federal law. You cannot comply with both at the same time, right? In that case, right, the state law is just preempted. It's void. The federal law controls, right? It's very easy usually to see direct conflicts. If you have a law that you cannot comply with both at the same time, the federal law controls, right? Under the Supremacy Clause, federal law is supreme law of the land. Federal law is going to preempt the state law. You treat the state law as void, federal law controls. Right, the third option under implied preemption is going to be where federal law implicitly preempts state law when the state law indirectly conflicts with federal law. Right, this is usually where the state law creates an obstacle to or frustrates the accomplishment of the federal law's purpose. Right, the good case I like to use here is Perez v. Campbell. Right. So essentially what you have here is an Arizona financial responsibility law, right? And most people I'm sure are aware of federal bankruptcy law, right? The idea of federal bankruptcy law is if you get into so much debt, right, you just accumulate so much debt, you get yourself into a hole, right, you have no other options, you can declare bankruptcy, right? There's a lot of penalties and reasons you really don't want to declare bankruptcy if you can avoid it, but as a last resort, if you're just in so much debt and you have no alternative, right, you can declare bankruptcy and essentially you do get a fresh start, right? This is the purpose that Congress has enacted federal bankruptcy laws, right? This is the point behind federal bankruptcy laws. The idea is, look, if you're in insurmountable debt, you have no option, you can declare bankruptcy and sort of get a fresh start, right? You can start over with your debt behind you and try to go from there, right? That's the idea of federal bankruptcy law. Well, Arizona passes a financial responsibility law that deals with car accidents, right? Basically, if you get into a car accident in the state of Arizona and you get into debt as a result of that car accident, right? And you fail to pay off that debt, the state of Arizona can suspend your driver's license, right? That's the crux of the law passed by Arizona, right? If you cause an accident, right, and then you get into debt because of that accident and you can't pay off that debt, Arizona can, as kind of like a penalty, suspend your driver's license, right? This is to incentivize people to carry insurance, right? If you're going to drive, it incentivizes Arizona motorists to carry car insurance or auto insurance, right? So eventually what happens here, right, we have the Perez family. Perez gets into a car accident, right, in Arizona. And he accumulates debt. He can't pay off this debt. He eventually declares bankruptcy under federal law. So he declares bankruptcy under federal law. He's trying to get a fresh start on life after his bankruptcy. But Arizona, right, applies this financial responsibility law and suspends his license, right? So now he's got this suspended license under Arizona law, and he's like, hey, look, right? So this goes to court, and basically his argument is that the federal bankruptcy law should preempt the Arizona financial responsibility law. He's saying, look, this Arizona financial responsibility law really frustrates the accomplishment of the bankruptcy law's purpose, right? This bankruptcy law is all about letting me start over, right? It's about getting a fresh look on life. How can I do that if I'm still being penalized for my debt, right? I've already gone through all the bankruptcy proceedings. I've paid the penalties for declaring bankruptcy, yet I still have this penalty over my head under Arizona law, my driver's license being suspended. To truly get a fresh look on life, right? To truly get the intent behind or the purpose behind this federal bankruptcy law, I can't have my driver's license suspended. You know, how am I going to get to work and get my job back and do all of this stuff if I don't have my driver's license law, right? So if I don't have my driver's license under this financial responsibility law. And here the court agrees with Perez and basically says, yes, here the federal bankruptcy law does preempt the Arizona financial responsibility law because this financial responsibility law really creates an obstacle to and frustrates the accomplishment of the bankruptcy law's purpose, right? Perez can't really get a fresh start here, right? He's still being penalized for his debt under Arizona law when he's supposed to be forgiven for his debt under federal bankruptcy law, right? And that's Perez v. Campbell. That's really indirect conflicts. Now, if you actually read the Perez v. Campbell case, the court uses the language direct conflict a lot in there, right? For our purposes, it's not really a direct conflict, right? That case is way back 50 years ago before the case law has developed as much as it has today. Today, we would probably call that an indirect conflict. Direct conflicts is really where it's virtually impossible to comply with both laws. And in that case, right, important to recognize that it is possible to comply with both laws at the same time, right? We can comply with the federal bankruptcy law, right? Perez can go through the federal bankruptcy proceedings and he can have his Arizona driver's license suspended at the same time, right? There's no direct conflict between these laws. It is absolutely possible to comply with both of them at the same time. Right? So it's not necessarily a direct conflict like our runway example, right? One's 250 feet, one's 200 feet. There's no in between, right? You can only comply with one or the other, right? This, under Perez v. Campbell, it is possible to comply with both laws. However, complying with the Arizona law really frustrates the purpose of the federal law. That's why we say it's an indirect conflict and it's still implicitly preempted. Right? That's kind of the difference between direct conflict and indirect conflict. Okay, but these are the three areas of implied preemption. Again, field preemption, direct conflicts, and indirect conflicts. So the last area that we have to think about with direct conflicts, indirect conflicts, and kind of the relationship between federal government and state government is a dormant commerce clause analysis, which we're going to get to in our next lesson. If you remember though, just to preview that a little bit, under Article 1, we say that Congress has the power to regulate interstate commerce. But nowhere in the Constitution does it say the states don't have the power to regulate interstate commerce, right? So the regulation of interstate commerce actually falls right here, right, in this concurrent power area on the Venn diagram, right? States have the power to regulate interstate commerce, and we know under the commerce power, federal government has the power, Congress has the power to regulate interstate commerce. So what do we do though when the states are regulating interstate commerce, right? Because we think of this more as a dominant federal power. So the dormant commerce clause is kind of a principle we infer from the Constitution. It's not actually expressly written in there, it's just developed from the case law, right? It's a principle we infer from the Constitution. It just poses some limitations on the ways in which the states can actually regulate interstate commerce, and that's what we're going to get into in our next lesson. But until then, guys, I wish you all the absolute best, and I'll see you at our next video.